Chapter 15, The Legal Implications of Health Reform. Let's talk a little bit about working with legal counsel in a collaborative environment. Here, partnerships are formed between providers and legal counsel. This partnership is necessary due to the ever-changing healthcare world due to the increase in legal risks. Lawyers guide the application of law and challenge the status quo. This is done through advocacy for their direct clients and which results in better outcomes for patients. Lawyers work closely with risk managers. Even though this is not required, it is preferred to ensure appropriate and complete mitigation of risk. Risk managers are wise to engage legal counsel to prepare for expected challenge to the provider's actions. Here, risk managers will access the areas of legal risks of an activity. They will apply regulations, laws, and court decisions. They'll also provide planning and guidance for new concepts and educate and train physicians and hospital workforce on risk. As we all know, there are three branches of government: the legislative, judicial, and executive. All three branches have influence over any changes in healthcare today. Also, they are sensitive to the need to protect the most vulnerable population. Under the legislative branch, they pass laws and deliberate on the views of various stakeholders to proposed legislation. The executive branch regulates and licenses professionals and facilities and issues regulations as required by state and federal laws. Here, the enforcement of all laws and regulations fall into this branch. And then the judicial is represented by the state and federal court systems. All three branches play an important role in creating and enforcing regulations that protect healthcare providers and patients. Court decisions interpreting laws and regulations impact risk. Here at the institutional level, these decisions will affect how care is delivered by the institution. The same goes for the patient level. These serve to protect the rights of all patients in all matters related to receiving healthcare services. And then state constitutions important to any risk analysis. The jurisdiction of certain legal proceedings is mandated to the federal courts and others are left to state courts. Implementing the population health agenda. Now, this agenda includes providing comprehensive care and treatment for chronically ill patients. The combination of incentives and penalties are aimed at achieving the desired changes and deterring inefficient or lower quality practice. So we offer incentives for providers. We also do penalties for providers. It's a community-based standards, improving overall quality and efficiency. It's compliant with the Affordable Care Act, and also it assesses legal risk of each and make a choice. Patient advocacy. Protecting the neediest populations. The government shows compassion for less fortunate, but also provides affirmative protection for those who cannot protect themselves. Privacy rights of such populations. Protection has most recently been extended to patient information contained in medical and pharmaceutical records, and the prevention against taking out such data at the individual patient and physician level. Also, patient advocacy requires additional risk management training. Special attention to training and compliance with the laws. Constitutional law protections through federal court decisions. These play a significant role in advocacy for an expansion of health care and legal protections for these special populations. There is a heightened awareness of medical errors. Risk managers track and trend errors and other occurrences while working closely with legal counsel for guidance on the law. And then utilization of medical and legal partnerships. Organizations of physicians and lawyers working together to identify and improve environmental and social risks that will contribute negatively to a patient's health. Professional licenses. Now, the state police power under the U.S. Constitution. Most professionals must be licensed under state law, although reciprocity is common for some professions. Most professions have no national license. Now, there is something called the Nurse Licensure Compact. Now, this is a federal compact approach that would permit nurses to practice across state lines. Right now, 24 states are part of this compact. This would be like a driver's license to say. This is the most progress in the nation toward a national licensure. Now, there are new federal initiatives toward professional licenses. Also, there's review legal standards and procedures for discipline, and also developments relating to telemedicine. So under professional liability, we have the tort system. Now, this defines what constitutes injury and the circumstances under which the responsible party should be held accountable. We also have defensive medicine. This refers to the practice of recommending a diagnostic test or medical treatment that is not necessarily the best option for the patient, but an option that mainly serves the function to protect the physician against the patient as a potential plaintiff. Now, the defensive medicine significantly drives up healthcare costs. Negligence. Now, tort system provides an opportunity to correct the wrongs of negligence. In order for negligence to be determined, an injury must have occurred, usually physically, and the provider must have breached the duty to perform a procedure or make a diagnosis and direct treatment correctly. Now, these are going to be governed by the standards developed in a particular jurisdiction. State reporting of serious gap in care. Serious misadventures must be reported to state licensing boards, accrediting organizations, and patient safety authorities. Some states publicly report misadventures. And then the standard of care. Now, this is a development of a set of standards by the National Boards of Clinical Experts, subgroups that reflect local practice differences associated with patient locations, like a rural community, and then also some other evolving standard. Under today's tort system, an admission of error is a huge gamble for the individual's professional and/or institution. Since it is an admission against interest and purely voluntary, it can be used as evidence in a court of law. So right now, apology laws are controlled by the state. The statutes control the particular requirements, and there are implications of the apology. So this requires that the individual professional and institution provide the specifics of what happened to the patient and the patient's family immediately after discovering the problem. The apology includes a description of the steps being taken to avoid a reoccurrence. Family and patient interaction. Now, if an error happens, the physician and/or institution might agree not to charge the patient for the procedure or medical treatment in exchange for the patient and the patient's family not suing for damages. So will this all stop lawsuits? I don't know. That's a good question. Me personally, I don't believe it will, but I bet it will deter most of them. Privacy laws are applicable to all healthcare providers. State laws continue to protect confidentiality. HIPAA designed to provide national standards for privacy and security of health information. So in 1996, Congress enacted HIPAA to protect health information held by providers and employers. The purpose was to protect all electronic health records, but was soon interpreted to cover all records in any format. Under HIPAA, state law preempts federal law where HIPAA requirements are less stringent. Now, PHI, which is protected health information, this is a term used when referring to patient data and information that must be protected by law. HITECH has increased requirements and penalties. HITECH changed who is covered, what is covered, and how interactions with state law operate. HITECH also sets forth new rules of compliance and enforcement of HIPAA generally. Breach notification rules. This is federal requirement to notify individuals of the breach of their PHI. Actions are being brought in both the state and federal courts when there are breaches of or failure to secure PHI. Enforcement by state attorney generals and FTC. Here, since there is no federal private right of action for violations of HIPAA, these groups are taking on new responsibilities for breach notification and other violations of HIPAA and privacy and security laws. And then health information exchanges. Permit providers to share PHI across the boundaries and also currently operate locally or regionally, but want to make it operate nationally. Provider tax status. Development of acute care hospitals as mission-based, not-for-profit, or charitable organizations is a unique characteristic of the U.S. hospital system. Now, there has been some scrutiny over nonprofit providers. Many feel nonprofit organizations are motivated by profit, getting scrutiny since 2006 as a condition of maintaining tax-exempt status. For-profit organizations complain the fact that they lack the tax financing opportunities as a nonprofit would get. And then also tax-exempt status is granted by the IRS. It exempts the organization from paying of taxes on earnings derived from its operations and investments. Now, this have a significant advantage as they are permitted to finance capital and operating expenses through tax-exempt indebtedness, sold to the public and large financial institutions at a lower rate. And also, tax-exempt status provides relief from state income and sales tax, as well as local real estate and business taxes. Employee Retirement Income Security Act. Now, this regulates employer-based health insurance plans. These actually are for employee benefits. It's governed by state or federal law, and larger employers receive uniformity under ERISA. Now, this shields employer sponsors against malpractice actions that can lead to damage rewards for pain, suffering, lost earnings, and cost of future medical care as a result of withholding care of treatment. Typically able to bypass state-mandated benefits, one of the cost drivers of higher healthcare costs for employees. And also, too, the protection from medical malpractice and impact of the Affordable Care Act on employer health plans. Employer-based insurance. Now, they are usually tax-driven, so the primary benefit of the employer sponsorship is the ability granted to employees to exclude the cost of health coverage from their income when determining their federal and state income taxes. Some may include wellness benefits, so employers experimenting with incentives for their employees to take better care of their health, fitness memberships, smoking cessation classes, monitoring of health indicators like blood pressure, weight, or blood sugar. Discrimination for medical conditions are protected, so the Affordable Care Act eliminated pre-existing conditions as a reason for denying coverage and provided for free preventative care with most health plans. And then Genetic Information Non-Discrimination Act of 2008. This protects employees from employers who might utilize personal genetic testing information for hiring and firing decisions. Since many patients are demanding genetic testing to see if they are at risk for current or future disease predictions, these become new risks for providers. This act protects employees while seeking this information. So in conclusion, the Affordable Care Act has increased challenges of laws. Lessening of the impact of a fragmented delivery system, and also addressing population health requires an understanding of U.S. and state constitutional law, healthcare statutes, and regulations. Any reform to the fragmented and complex healthcare system must be given careful consideration to the legal concepts that provide guidance and oversight. So this concludes Chapter 15. If you have any questions, please let me know. Thank you.